Okay, welcome today to our next section of the introduction to criminal law. We call criminal law 100. Uh, Sorry, I think the weather is very, very bad. The internet is stable. But however, we still try to proceed. We try to proceed as much as possible and cover some of the topics. So, in the criminal law 100, we continue with the topic, the basis of criminal liability. When you hear they say the basis of criminal liability, under Liberian law, it means the the condition under which you can be held criminally liable for a criminal offense. That's why we call it the basis of criminal liability. The penal law of Liberia or the criminal law of Liberia listed and defined specific intent. You know, the requirements of voluntariness first is that in order for your act to be voluntary, you must have uh, the will to do so, the free will. And the element of intent must be concerned basically with the requirements of the types of culpability or the types of intent, criminal intent. And, and the types of intent under Liberian law or culpability grounds that intentionally, willfully, negligently, and recklessly. If for any reason you engage in an act that you you had a purpose for doing so. Sometimes some people say the motive. You had a purpose for doing so, you can be held liable for that particular act. One of the elements of criminal liability is purposely. If you purposely committed an offense, you can be held liable for the commission of that particular offense. That means that if you have engaged in a conduct that while engaging in that particular conduct, you had a conscious objective to engage in a particular act, specifically the nature of the act, or you cause the result of the conduct. Once you are the one that caused the result of the conduct, or you engage in an act with a conscious mind, then you have satisfied the requirement of culpability called purposely under the penal law of Nigeria. The next element of criminal liability, the next element under which you can be held criminally liable for an offense under Liberian law is when you knowingly committed the criminal act. The knowingly element is referred to as if you engage in a conduct that you know is harmful, and that because you have the conscious belief to do so without any doubt of doing it, then you have satisfied the element of knowingly. The first element was purposely, when you conscientiously decided to engage in the criminal conduct. The second element is knowingly. You know, purposely, knowingly. If you engage in a conduct that you know that that conduct will result into a harm, and you have no doubt in your mind and you have belief that engaging in that act will cause harm to another person, as defined by law, you have satisfied the element of culpability called knowingly. You knowingly committed the act. You know that the conduct was wrong. You know that at the end of the day, it will result into harming somebody, or somebody will be injured. Then you have satisfied the requirement of knowingly. The next element of criminal culpability, in other words, criminal liability, or the next element under the criminal law that you can be held liable is called recklessly. That's another element of culpability. Recklessly. If you engage in a conduct with a conscious mind, and you engage in that act with a clear, unjustifiable disregard of the consequences that will follow, then you have followed the criminal element of culpability called recklessly. The conscious mind of knowing, of getting involved in an act that you believe and you had no justification in the disregard of the consequences that will follow. You have engaged in an act that satisfies the requirement of recklessly. You say, oh, the man acted recklessly. He was reckless. It means he knew that the conduct was wrong. He was taking risks. He knew that the act would cause harm. And he had no justifiable disregard of taking the precaution of the risks that he was taking. You can be here for that. Let's take, for example, you got in a car. The car gave you a signal that the brakes are gone. Then you took the car. If I take it to the mechanic and you know the car brakes are gave up, you decided to get in the car to run in a crowded area, knowing fully well that you should have called the mechanic, not to get in the car, to take the car from that particular area. But you decided, you knew that indeed it was risky in getting in that car. And you decided to run to the car. And you knew very well when there are no brakes on the car, it will be dangerous. That was a risk you took, and there was no justifiable disregard for that risk that you took. Obviously, you can be there for reckless endangerment of the life, safety of other people. So that one will be by recklessly. Let's look at negligently, another element of criminal law under which you can be here liable criminal under our Liberian law. This is the penal law of Liberia. We're teaching this course from the context of the Liberian criminal law. Negligently is if you engage in a conduct with unreasonable disregard of the substantial likelihood of the existence of relevant fact or risk, then you have engaged in a negligent act. You were negligent. You have no justification for the act that you have committed. Another element that I'd like to bring to your attention is willfully. What is meant by willfully under the penal law? If you engage in a conduct that you purposely and knowingly engage in that act, then you have willfully engaged in the criminal conduct. If you purposely and knowingly engaged in a particular conduct. You get that? And you believe that what you were doing is voluntary. You purposely, you consciously did it. You calculated, you knew the consequences of the action. Then you have satisfied the requirement of willful intent. You willfully committed the act. That is another criminal element of intent or criminal liability. Then we look at the other requirement of culpability. If you engage in a conduct purposely, knowingly, recklessly, or negligently, I have just defined, then you have met the requirement of culpability. Remember, I defined for you what is meant by purposely, knowingly, recklessly, and negligently. So if your conduct has all of these elements, then you have met the requirement of culpability. In other words, criminal liability. You have met the condition of being held criminally liable for particular offenses. Now, this is why in the criminal justice system, crimes of manslaughter, you will always observe the negligence, the recklessness in as element. If the criminal conduct was done recklessly that led to the cause of death, you will hear about manslaughter. You will not hear about murder. But when you hear about willful, purpose, knowing, then the issue of murder always appears as a proper charge against the person accused of killing another person. But when the element of negligence or recklessness comes out, then you're talking about manslaughter. Manslaughter is the killing of another human being. But the mental element was recklessness or negligence. If the element of culpability of negligence exists in the conduct of a person that led to the death of that person, then you will see the charge of the person for manslaughter, not murder. But murder exists where you knowingly decided to kill, you purposely decided to kill, and willfully decided to kill. Then you fall under the criteria of being charged for murder. So when you see in the material, we talk about a kind of culpability. So you see that we listed them purposely, let's say knowingly, purposely, intentionally, willfully, negligently, and recklessly. These are the kinds of culpability. So under the criminal law, the requirements of culpability generally, in terms of all of what we are talking about, has to do that the person is not guilty of an offense unless he acted purposely. No person is guilty of an offense unless he acted purposely. That is the law. Nobody is guilty of an offense except he acted purposely, knowingly, recklessly, or negligently as a matter of law. That is what our criminal law says under the basis of criminal liability. Now, you will come to another one you see here, which is somehow a little confusing thing. Ignorance or mistake negating culpability. I talked about it the last time in the criminal justice class. Ignorance or mistake or as a matter of law or fact is a defense. If the ignorance or mistake negates the purpose, the knowledge, the belief, the recklessness, or negligence required to establish a material element of that offense. But this is the case. Although ignorance or mistake will otherwise afford a defense to the offense charge, the defense is not available if the defendant will be guilty of another offense had the situation been as he supposed. In such a case, however, the ignorance or mistake of the defendant shall reduce the grade and degree of the offense for which he may be convicted of. Those offenses which he would be guilty had the situation been as he supposed. In other words, what they're trying to say here is that under our criminal law, in general, ignorance of the law excuses no one. Mistake of the fact excuses no one. But if out of these conditions, a person had engaged in a criminal conduct where the culpability, the elemental culpability of purposely, knowingly, willfully, recklessly, or negligently exists, he may not be criminally liable for the essential element of the particular crime committed. But he is not going to go free. He may be charged for a lesser offense relating to that particular crime. You're not going to go free. You say, oh, the sake of the law, so you excuse me. No. Ignorance of the law, no. If your ignorance affected to the amount that it negates one of the elements of the crime charge, he said, oh, that man did not really calculate this act, therefore murder. He actually did not calculate this act. He did not premeditate. He did not deliberate. You know, in murder charges, we say murder is the killing of another person with premeditation, malice, aforethought, deliberation. So, he did not do that, but he was reckless to some extent. They may not hold him for murder, but they will not let him go. He might be held liable maybe for reckless endangerment of life, or they can hold him for manslaughter. He can't just go free. So the general rule is, that's why they say, ignorance of the law excuses no one. Ignorantia legis nomini excusate. Ignorance of the fact excuses no one. That's the general rule. But there are exceptions. Those are the exceptions that I have just given. The next area that I want us to reach to is the accomplices doctrine. Accomplice liability. Corporate criminal liability. First, you need to know the doctrine of accomplice. Accomplice in criminal law, it means that the person, generally, who helped a man to commit a crime, that person is also treated as the principal. In other words, anyone who helped somebody that broke into a bank and stole money, that person is equally guilty as the man who broke and entered into the bank. I'm just giving you an example. So, if you assisted a person to commit a crime, you don't necessarily have to be on the crime scene. In criminal conspiracy, you don't necessarily have to be on the crime scene. You can be held liable for that particular offense. That is the doctrine of accomplice liability. You can aid the person before the commission of the crime. You can aid the person during the commission of the crime. You can aid the person after the commission of the offense. That's what we call accomplice liability. In the common law system, some people call it accessory before and after. It depends. Accessory before the act is assisting the person in the preparation for the commission of the offense. Accessory during the act, while the person who committed the crime, you assisted. Accessory after the fact, while the man has committed the offense, you have to conceal the information. You have to conceal the fruits of the crime. The fruits of the crime is what we call the body of the crime. Okay? The fruits of the crime. Now, we look at corporate criminal liability. A corporation can be held criminally responsible based on the conduct of its managing director or CEO or corporate official. If the corporate officials were engaged in a criminal conduct in the discourse or the performance of their job, the corporation is equally liable. That's what we call vicarious liability in criminal law. For example, if you have a corporation and you are the manager or managing director or the president of the institution, and then you went to work and evaded taxes, which is a criminal offense. Under chapter 14 of the penal law, it's called economic sabotage. You are held liable for violation of the criminal law or a first degree felony under Liberian law. And at the same time, the corporation is criminally held liable for that particular offense. That is the law. When the corporation is criminally liable, the rate will be issued, and that rate will be a rate of summons, not a criminal rate or rate of arrest. It's a rate of summons. So, that is the doctrine of accomplice liability when it comes to corporate criminal liability. The next one is, let me see well, is criminal liability of associations other than corporations. They say a partnership, for example, a joint stock company or an unincorporated association, meaning a company that you operate, you have not incorporated it. It is also legal, including a cooperative association. They may be convicted under the circumstances corresponding to the one we talk about under corporate criminal liability. In other words, what we are saying is that a partnership, a corporation, a joint stock company, and any other association, its officials can equally be criminally responsible, like as in the case of a corporate criminal liability doctrine, like the one we talk about corporate criminal liability, like a corporation, partnership, joint stock partnership, joint stock corporation, all of them. When they engage, their officials engage in criminal conduct, they can be held criminally liable. Then we look at the individual criminal liability for conduct on behalf of the organization. Under this, when we say organization, it means a corporation. It means partnership. It means joint stock company. It also means unincorporated association. including cooperative associations. Conduct on behalf of the organization. A person is criminally responsible for any conduct he commits or performs or causes to be performed in the name of an organization or in his behalf, to the same extent as if the conduct were performed in his own name or behalf. So, individually, you can also be held criminally responsible, even though you operated in the name of the corporation. You can say, oh, and I to be involved. It is only my company that I performing on behalf of the company. No. Under the criminal law doctrine, this kind of doctrine, this doctrine of individual criminal liability for conduct on behalf of the organization, you as an individual can be personally liable for a criminal conduct that you carry out in the name of the organization. Then we'll look at the exemption of foreign ambassadors and public ministers from criminal liability. Ambassadors and public ministers of any foreign state or other persons enjoying diplomatic immunity, together with members of the household and families, shall not be subject to arrest, trial, service of criminal process, or conviction for offenses committed within the Republic of Liberia. But the foregoing exemption shall not apply to any person who is a citizen of Liberia in the service of an ambassador, public minister, or other person enjoying diplomatic. All Liberian diplomatic officials and public ministers do not enjoy immunity when it comes to criminal liability in Liberia. If the man is a Liberian ambassador to Sierra Leone, he does not enjoy immunity. If he is an ambassador in a different country, he does not enjoy immunity. If you are a public minister or official of government, you do not enjoy immunity. But a public minister of another country and or an ambassador of another country that enjoys diplomatic immunities coming to Liberia cannot be subject to a criminal trial under Liberian law. They cannot be arrested. That includes their households. All of those that work with them, you can arrest them. Let me say that again. An ambassador from different country who works in Liberia, that Liberia confers diplomatic immunity on, cannot be the subject of our court's jurisdiction, cannot be the subject of a criminal rate or of arrest, cannot be the subject of a criminal trial under Liberian law, who enjoys diplomatic immunity. In addition to him, you can say even the people, his wife, his children, or her husband, her children, her maid, members of her household or his household, those that work for him, cannot be subject of a criminal trial. Not only him, all of those that are employed in his household cannot be the subject of a criminal proceedings. We cannot arrest them. In addition to that, you cannot search their homes. You cannot search their cars. You cannot subject them to search and seizure. You cannot, because they are covered by diplomatic immunities. The doctrine of diplomatic immunities was sealed by the Convention of Diplomatic Immunities that was signed by Liberia and other nations under the United Nations. Liberia is a signatory to that particular convention that says that ambassadors and officials of foreign nations who come into your country are prohibited from being arrested by that nation's law enforcement entity. You cannot subject them to criminal jurisdiction and trial under Liberian law. Okay, so that is where we are today. We'll stop there. The next time we come to the next area that has to do with defenses involving the lack of culpability, justification. So let's start there today to the basis of criminal liability, and then next week Thursday we can proceed or we can continue with the subject. Thanks for listening and thanks for being part of the class. Thanks for watching. If you have, and whenever you're in class, you have problems or questions, you just put them in the chat or the comment section, and then we can look at that. Somebody was talking about local staff. They are exempted, but they have what we call qualified immunity. Qualified immunity. That when you do international law, under international criminal law, or international law specifically, you will know that they have what we call absolute immunity and qualified immunity. There are those Kekula Masako, he said the law is unfair to our Liberian diplomatic officials. Not for other countries. It doesn't mean the Liberian citizen, so it means you're above the law in Liberian law. There are people who are covered. There are people who are covered by immunity, the Liberian like Liberians, but they have qualified immunity. You can't just arrest them and just put them in jail. No. You will communicate with the agency, like the way we had the Liberian staff who were working with the United Nations or who are still working with the United Nations. You can't go to the UN compound and have them arrested. Based on the state of before we used to Liberia sign something we call state of forces agreement. Okay, there are certain people that were exempted. You can't just jump on them. So the Liberian staff have what we call qualified immunity, especially when they are performing diplomatic functions. You can't just jump on them. There are procedures. The court will vet the institution because the thing is about the doctrine of reciprocity. You do me, I do you. The way you respect me is the way I will respect you. It's an exchange in international relations. So the court, the institution, the government can write the institution, through the court will write, and then maybe the government, the justice minister will write, say, well, this person is the subject of a criminal investigation. We ask you to excuse them, let them answer because they are Liberian citizens. Okay, you can do that. But you can't just go arrest the person who is performing a diplomatic function for the foreign mission. It's for the purpose of dignity, of respect, that's all. In international relations, it's just about respect, reciprocity, respect each other, the exchange of respect for one another. That's what it's all about in international relations. That's why you see some countries, when they observe that you treat their citizens in another country, then some people can start taking some measures against your own citizens. That reciprocity. That's international relations. So let's stop there today. Thursday we'll continue with criminal law 100. Tuesday is continuation of introduction to criminal justice. Good day. Please go on the Facebook page and subscribe. And take your time if you don't understand, because this course is a very hard course. This is one of the difficult courses in the law school or all over the world. This is a serious course. So I know it's very complicated, especially here. These concepts, these doctrines, they are very complex when you start going into detail. So when you have any question, just put it in the comment section. Put it there, then we'll be answering them. But I will be taking my time. I'm not going to be rushing to write the brush. But when you don't understand it, you just go back and do the replay. You also follow. That's why the online learning is a very good one. It's one of the best because it helps you to capture. If you did not understand the professor, then you go right back and replay until you can understand it and move forward. That's the happy heart. Because it is recorded, it is there, it is kept for good. Good day.